Good evening, and welcome to the Mercedes-Benz lecture, Constructing the Right to Vote, by Joshua Sellers, who is the fall 2020 Mercedes-Benz Fellow here at the Academy, at the American Academy in Berlin. Dear Joshua, it's an honor and a special welcome to you. The Academy has many reasons to be grateful to Mercedes-Benz, and one of them, and the most important one of them, is the fellowship, which was endowed in 1999 with the purpose of bringing at least one fellow per year to the American Academy from a variety of fields. And the variety of fields is expressed in the list of fellows that had been here before, most recently comparative literature scholar Emily Apter, political scientist Stephen Klein, film scholar Nora Alter, historian Lawrence Douglas, and of course tonight's speaker Joshua. He is an associate professor of law at the Sandra Day O'Connor College of Law at Arizona State University, which he joined in 2017. Professor Sellers focuses on election law, legislation and regulation, constitutional law, and civil procedure. He holds a JD and a PhD in political science from the University of Chicago. And at Chicago, Professor Sellers also worked as an articles editor from the University of Chicago Law Review. He was an associate professor at the University of Oklahoma College of Law, a postdoctoral fellow in law and politics at Syracuse University's Maxwell School of Citizenship and Public Affairs. Before he started teaching, Joshua also had a life. As a law clerk to Judge Rosemary Burkett of the U.S. Court of Appeals for the 11th Circuit, and he was also a litigation associate at Jenner & Block LLP in Washington, D.C. His articles have been published pretty much everywhere, amongst others in the Penn Law Review, the NYU Law Review, the Vanderbilt Law Review, Stanford Law Review. His forthcoming contribution to the Oxford Handbook of American Election Law in 2023, I think, is entitled Political Parties and Primary Elections. One of his studies that I can highly recommend is his Democracy on a Shoestring in Vanderbilt Law Review, where Joshua in 2021 and his co-author Roger Michalski study government funding of elections and compare data on election expenditure from 4 U.S. states. After this evening lecture and later also reception and food and more wine, you please all go home, Google that and read it. At the Academy, Joshua spends most of his time working on his project titled The Law of Democracy and Racial Equity. In it, he bridges the disciplinary divides of legal and non-legal scholars with the aim of locating the racial ramifications of the law of democracy. Gladly, and we're very happy that Joshua is not only working, he has a huge interest I want to say everything, but that wouldn't be true. But one of his interests is certainly Berlin's music scene, the classical music scene, and he comes with an incredible knowledge of Berlin-based restaurants. He gets in every restaurant, and he has really a wonderful strategy to make reservations and everything. So if you need recommendations or a place at a very popular spot, talk to Joshua. Before we talk about that, Joshua has to work. He will now deliver his lecture, and afterwards also be taking your questions. So prepare some, challenge him, and if you're joining us from the Zoom world, you are, of course, also free to ask questions. Please use the Q&A functions on the bottom of the screen, and we will make sure to address every question. Dear Joshua, it's an honor to have you. This floor is yours.
Well, thank you, Barrett, for that warm introduction and for mentioning the Democracy on a Shoestring article, which, ties in nicely with the topic that I want to discuss tonight. But let me start by thanking all of you for coming. I know it's a little bit of a trek to come out to Wannsee in the middle of the week for some of you, so I appreciate that and I'm grateful. I want to thank Dan Benjamin and the leadership of the Academy for providing the space so that we can have these conversations, which I think are as important as ever. I want to specifically thank the programming team who helped put this together. So thank you to Barrett, of course, and Caitlin Hahn, who Of course, has moved on to other endeavors, but I think she was the first person that I corresponded with when I was planning this lecture. So thank you to Caitlin, thank you to Robert, and thank you to Johanna as well for all that you're doing. I'm going to keep the mask on if that's okay. All right. Yeah. Thank you to the Academy staff as well for making this such an inviting atmosphere and taking such good care of us. Thank you, of course, to Mercedes-Benz for sponsoring my fellowship this semester. I'm greatly appreciative. And last but not least, of course, thank you to my fellow fellows and their partners as well for what has been a very collegial, enriching couple of months here. And none of us really knew what we were entering into when we showed up, right? We signed up to live with 9 other people in a villa in Wannsee in Germany for a few months, which has the makings of a bad reality show, potentially. But it's been a pleasure to get to know you all, and I very much look forward to the next couple months. So thank you. So it's sort of cliche or blasé at this point to talk about the threats that American democracy confronts. Some of them are, of course, long-standing and structural. The Electoral College, for instance, has given us a situation where 2 of the last 5 presidents have lost the popular vote. Trump, of course, lost it by over 3 million votes. And experts think that that trend will continue, where there will be this divide or the discordance between the winner of the Electoral College and the winner of the popular vote. So that is one of these long-standing structural threats to the legitimacy of our elections. The Supreme Court is, of course, now thoroughly dominated by conservative justices, and that will be the case for years, if not decades, to come. And even before the 6-3 majority took hold, I think it's fair to say the court was no friend to democracy, whether by gutting the Voting Rights Act on a couple of occasions, and I unfortunately fear that they will do that again this term in a case that was just argued a couple weeks ago. Basically sanctioning political gerrymandering, which is one of the endemic problems we have in the United States. The Supreme Court said federal courts are going to get out of the business of policing partisan gerrymandering. So to the extent that there's a remedy for that, that remedy will have to come from the states. And in the campaign finance doctrine, allowing more and more so-called dark money, which is money for which we don't know the source of, to infect our political campaigns. And so this is not the Warren Court. There is not a reason to look to the Supreme Court as a sort of savior or as a friend of democracy. In terms of Congress, which of course could act to remedy a lot of the political ills that we see, Congress has its own deficiencies and failed to pass, as many of you know, 2 recent election-related bills that got through the House but stalled in the Senate, in part because of Senator Joe Manchin from West Virginia, and I would be remiss if I didn't mention one of my own home state senators, Kyrsten Sinema, who they both have this abiding faith in the filibuster as a means of promoting bipartisan communication and harmony, even when our democracy is under threat. So little reason to look to Congress or the federal government more broadly, I would say, for help in reforming elections at this moment. At the state level, we're seeing some progress in blue states where we have expanded voting rights in places like New York, and those states are making attempts to bring more and more people into the political community, even including non-citizens in some cases. But, of course, in red states, we're seeing the opposite. We're seeing very aggressive attempts to suppress votes, and as many of you surely read about, in states like Georgia, we have very onerous election laws that, among other things, prohibit the distribution of food and water to people who are standing in line to vote. Of course, raises the question, why are people standing in line so long that they might want or need food and water? Not to be outdone, in Michigan, the legislature has just recently criminalized hiring a private driver to take you to the polls. Now, you would wonder, why would the legislature get together and enact that law? Well, in part because there were organizations that particularly black voters would rely on that would rent buses and vans and take them to the polls. So the Michigan legislature thought, let's ban the hiring of private drivers. So ostensibly in Michigan right now, if you take an Uber or a Lyft to go vote, you may be criminally prosecuted. Now you would think maybe you could just file lawsuits to challenge this, but all of these laws I've just mentioned were recently upheld by judges in federal courts, including, with regard to the Georgia law, an Obama-appointed judge. So federal voting rights doctrine is also not very amenable to election reform and gives an enormous amount of discretion to states in how they want to regulate elections. We have thousands of election deniers who are not only currently serving in state legislatures. I think in Arizona, 81% of the Republicans in the state legislature are election deniers. These, of course, are people who think the election was stolen and that Joe Biden is illegitimate as president. But not only that, we have hundreds of these election deniers running for various offices, secretaries of state, attorneys general, in some cases governor, county recorders. And the strategy, right, is to position themselves so that when 2024 comes around, they will be in a position, if the presidential election doesn't go their way, to object, right, and to raise issues that will create constitutional crises and complicate the presidential election. This is a graphic from 538. The states that are entirely colored in are states that there's an election denier running for statewide office. The other states have various election deniers running for other offices within the state, not statewide positions. But as the Washington Post just reported 2 days ago, election deniers will make up more than half of all of the Republicans running for congressional and state offices in the midterms next month, which is extraordinary. Half of all of the Republicans running for any office next month are election deniers. So I'll come back to the state level because I do think there is some promise at the state level, but that is a somewhat bleak picture that I've presented there. And of course, you might think, well, let's turn to the voters, right? Democracy is contingent on people voting the bums out, right? If we disagree with what's happening, we can go to the polls and effectuate change. But unfortunately, we now have multiple studies showing that what the electorate and what the citizenry believes is also deeply problematic. So if you read Thomas Edsel's columns in the New York Times, for instance, he often summarizes a lot of these studies and finds that a troublingly large percentage of people believe things like violence is appropriate against your political opponents in some circumstances. A large percentage believes that the country is likely to experience something like a civil war in the near future. I was just reading earlier tonight a conversation in the Times Today with Jamel Bowie and Tim Alberta discussing the prospects of civil war, low-level political violence in the United States. A large percentage believe that white Christian America is under attack by immigrants and minorities and has to be actively defended. And there's also this view circulating even in elite circles that the traditional liberal framework, the rights-based framework that we've lived with, should be supplanted. So there's a view, I'm thinking of people like Patrick Deniers at Notre Dame or Adrian Vermeule at Harvard Law School, who argue that we should do away with the liberal rights-based framework and replace it with something resembling a traditionalist, family values-based, conservative, Christian/Catholic set of values that should inform our governance. So this is now, again, a view that you can find in elite intellectual circles. So I mentioned all this at the outset not to depress you. I apologize for that. Maybe we should bring the alcohol in early. But just to be sober-minded and honest about what we are facing and how difficult reform is in this particular moment, and to note that there's no simple solutions to be had. But that doesn't mean we don't have the obligation of trying to find avenues for reform and working to find ways to defend democracy. And I am very much in that frame of mind because I was asked to write an essay for the Yale Law Journal on what the future of my field should be. What should American legal scholars be doing, election law scholars, in this particular moment to try to advance democratic principles. And so this is an essay, I think it will be published in probably 2 or 3 weeks at this point. But what I argue for in this essay is a interdisciplinary research program oriented around the idea of electoral adequacy. So this idea of electoral adequacy is going to form kind of the core of my comments tonight. And the idea with electoral adequacy is that we should be working to establish a baseline level of election services that all states are obligated to provide. So researchers, legal scholars should be working with researchers from other backgrounds to try to do studies to figure out what reforms are working, what reforms are not working, how can we make a plausible case for what constitutes electoral adequacy. So what I'd like to do is talk about how I kind of came to this idea of electoral adequacy and then discuss the central components of it. And then I'll briefly describe how this aligns with some other reform projects that are happening both in the United States and here in Europe as well. But I want to make just a conceptual point at the outset, which I think often gets overlooked. And that's that voting it's just different than other rights, right? It's conceptually just different than other rights, even rights that constitutional law deems as fundamental. So for instance, if I want to exercise my free speech rights, really what I'm seeking is government non-interference, right? I just want access to the park. I want access to the mall. I want access to the soapbox. So I can say whatever it is I want to say, and I don't want the government to punish me for that speech, right? It's a negative liberty, we might say, that I'm seeking. The same is true for other rights. Think about the Fourth Amendment's prohibition on unreasonable searches and seizures, right? I just want to walk down the street and not be bothered by law enforcement unless law enforcement has very good reason to think that I might have engaged in wrongdoing of some kind. The same is true for what I think is our most controversial individual right, the right to bear arms in the U.S. I don't support that right. I don't think it's rooted in the Constitution as the Supreme Court does, but individuals who advocate for that right think that, they should be able to walk down the street and have a handgun in their waistband or have an automatic weapon on their person when they go to the fairground or whatever. But again, what they want is government non-interference. The right to vote is just categorically different because I can't exercise my right to vote unless the government provides the infrastructure and provides the apparatus that allows me to effectuate and fulfill that right. So we're already in a different conceptual space, right? We have to think about what obligations does the government have to us as citizens in constructing a right to vote. And this is why we have endless debates about this. This is why there's endless litigation about this. If I said to you all, we possess the right to vote, I think we would have a hard time defining what is constituted by that. Does that mean, you don't have to show an ID when you vote? Does it mean you should have 2 weeks of early voting before you vote? Does it mean you should be able to register on the same day that you want to vote? What does it mean, right? We have no agreement on that. So part of the idea behind this research program based around electoral adequacy is filling in those gaps, right, and firming up the foundation of how we understand the right to vote and giving it some content that it currently lacks. So with that in mind, let me describe how I came to this idea of electoral adequacy, and I actually came to it by looking at the history of education litigation in the United States. So education litigation is generally, for some reason, scholarship agreed on this being like 3 waves of education litigation. So this is how it's often described. And the first wave was in the 1970s where plaintiffs, these were parents, they went to federal court and they they brought claims under the 14th Amendment's Equal Protection Clause, and they said, my kids go to a low-resource school, and I think they should have the same resources as the kids in the wealthy schools. I want equal resources, right? Per pupil expenditures need to be the same. And the Supreme Court heard this argument in 1973 and rejected it, so parents sort of went back to the drawing board, and they said, all right, well, let's try again in state court. Right, let's go to state court and bring the same claims, the same legal theory under state constitutions. And so again, they sought equal resources distributed among public school students in state courts under state education provisions. And there was some success in the second wave, but not very much. And so plaintiffs' parents had to go back, and in the third wave, they changed their legal strategy. And they said, we're not seeking equal resources. We want an adequate education for our children, right? That's what we want. And so the argument was that states should provide all schools with some absolute base level of resources sufficient to provide a constitutionally adequate education, however the court may define that level. And I don't want to suggest that all of these cases were successful. They were not, but many were. And we've had billions of dollars transferred to public schools as a result of these educational adequacy lawsuits. And so when I looked at the history of education litigation and looked at the cases that actually established the right to an adequate education, what jumped out at me was how precise and how granular the judicial opinions were, right? Often you're used to reading legal opinions. They are generally at a certain level of abstraction. What was notable about these decisions was how much in the weeds they were with specific details that would constitute an adequate education. So to give one example, the Arkansas Supreme Court, this is in 2002 when it invalidated that state's public education system, found that one uncertified mathematics teacher, I like how they specified that it was an uncertified mathematics, not even a certified mathematics teacher. One uncertified mathematics teacher was deemed to have, the court said, an insufficient number of calculators for his trigonometry class. There were too few electrical outlets. There were no compasses. There was only one chalkboard. There was a computer lacking software. There was a printer that doesn't work, an inadequate supply of paper, and a duplicating machine that is overworked. Another school district was plagued, the court said, by leaking roofs and restrooms in need of repair. And one elementary school was cited for having just 2 bathrooms with 4 stalls for over 100 students. So it was findings like these in Arkansas and in Texas, where there was another successful adequacy case brought, that led legislatures and then administrators to wrestle deeply with what does it mean to have an adequate education. And when you look at the remedies, again, what's striking is just how detailed they are. It's like, if you have this many students, you need this many clarinets. Or there have to be this many VCRs or DVD players per pupil, whatever. And so what I'm arguing is that this is precisely what we need in the election administration context, is this idea of electoral adequacy, right, brought under state constitutional provisions, voting-related provisions, and democracy-related provisions in state constitutions that will do what occurred in many states in the education context. So that's how I got to this idea of electoral adequacy. And then the challenge was, of course, filling it in and really focusing on how do we define electoral adequacy and what type of issues should make up the heart of electoral adequacy. So there are 3 policy components that I put as part of the central framework of electoral adequacy. So I'll just briefly address these one by one. Adequate funding, Barrett mentioned this article that I wrote a couple years ago called Democracy on a Shoestring. The reason why this article got some recognition was because we know so little about what elections cost. The research has not been done to figure out how money is being spent, and most importantly, what is the relationship between the spending and the voting experience, right? We have all these problems and flaws we can read about in the newspapers. If you talk to election administrators, the number one issue that they cite is lack of funding. They don't have funding to pay poll workers. They don't have funding to print and mail ballots. They don't have funding to send notices to disabled voters who need, under law, those notices. They don't have money, and this is where there's real bipartisan support for cybersecurity, which is an increasing concern when it comes to elections. They can't upgrade their machines. And so this article, as Barrett said, looked at just the election expenditures in just 4 states. We looked at California, Arizona, Florida, and Texas. And it took us 3 years just to gather that data. We had to do records requests. We had to send emails to these small county recorder offices and say, how much are you spending on this? And even with that, we didn't have all the data, and credit goes to my co-author. We used machine learning to fill in the gaps of what we didn't have. But everyone acknowledges we just need much more attention devoted to funding and how that affects the voting experience. The second policy component is competent management, which sounds banal. You say competent management. Everyone needs competent management. If you're, working at a coffee shop, you need competent management. But this is immensely important in how elections function. These are the public and private organizations, networks, resources, and instruments involved in implementing elections. And we fortunately have models from political science and public administration that allow us to study management structures and identify how professionalism is formed and gets embedded, and how innovations are developed, and then how those innovations can be transmitted or migrated to other jurisdictions. So again, this seems sort of dry and boring, but we need much more investment in understanding the management structures of electoral institutions. And Eric Schwartz is here, who was the former dean of the Humphrey School at University of Minnesota. Minnesota is only one of 2 universities in the U.S. that has an election management certificate program. So if you're interested in being an election administrator, you can go to Minnesota, you can go to Auburn University, you can get a certificate that verifies that you've been trained. I have no idea why we have not replicated this elsewhere in the country. I feel like public universities should be doing this all over because staffing and professionalism and developing capacity in election administration is incredibly important. The states that tend to perform well in election administration, Colorado, Washington State, they pay well, and they have full-time staff, and they have all kind of expertise in place 12 months out of the year to prepare for elections. Think about what they're dealing with in Florida right now. You have a hurricane come through. We're on the eve of an election. These counties are dealing with flooding and death. They have to print new ballots. They have to mail those ballots out to voters, right? That costs money. That requires expertise that so many of these jurisdictions just don't have. The third policy component is democratic structures. These are internal governance structures that clarify the roles of state and local officials in administering elections. And, so that's part one, and second, include the representation of disempowered communities within the election administration sphere. So this deals with coordinating responsibility within a state. States are the chief implementers of federal law, and there are these coordination problems that arise because one part of the state government says it's not our responsibility, it's this other entity's responsibility. And then that entity says it's not our responsibility, it's the county's responsibility or whatever. One of my colleagues, Justin Weinstein-Tull, has a great article on this called State Bureaucratic Undermining. And sometimes courts have to come in and basically clean that up and organize bureaucracies such that there is accountability and information sharing, and there's not shirking. Because different parts of state government push off responsibilities to others. In terms of representation, this is simply observing that everyone involved with election administration, poll workers, law enforcement officials, election observers, everyone should reflect the communities that they serve, right? It's one of the reasons why we're so concerned about these election deniers running for these positions. We need them staffed with people who really represent the community and allow for feedback from stakeholders in the community and nonprofits and other to, provide accountability. So, this is my framework. This is based on what I understand to be the main problems that exist in election administration. I think even in this very fraught political environment, when we can't get results from Congress, we can't get results from the Supreme Court, we can do a lot by investing in shoring up this part of elections and voting. And in the essay, I use 2 examples I apply this framework to the issue of polling place wait times and the issue of voting rights for the disabled. So I use those 2 examples to show the virtues of the framework, but I really could have picked any number of issues to make that point. So people that have read this naturally ask, what are the odds of this being implemented? How can we accomplish this? And I can't overpromise, but I will say that election administrators, by and large, are good people, public servants. They want to improve election administration. They often are as interested in these scholarly studies as scholars are. I'm working with a political scientist at Cincinnati who has already gotten agreements from election administrators in Pittsburgh and St. Louis to give us data and information about the polling place experience in those places that we can use. So there's a lot of good people working in the system I think will be open to this. And when that's not the case, that's when litigation is necessary. And that's when I think going to state court and bringing claims under state constitutional provisions pertaining to elections might bear fruit. So I don't think this is a panacea. I don't think we can expect comprehensive election reform from this litigation. But electoral adequacy is not seeking comprehensive electoral reform. It's just seeking targeted reforms based on data and deliberation. And again, to go back to my sort of theme here is legal scholars in particular, we tend to operate in silos. And we're not as open to cross-disciplinary collaboration as we might be. But I think at this moment in this context, this is exactly what's needed. Let me end by just talking about how this aligns with other projects. I think one of the benefits of this framework is, that there is synergy with other projects that are going on. So there's a kind of growing body of literature on comparative election administration. And in fact, the UN has invested in that and called for more studies of that type. So you have scholars in Europe who are developing criteria that allow us to compare electoral management bodies across countries. And this is always a sort of tricky thing because systems differ so much. But the work that I've seen is pretty good at holding certain things constant and comparing what can reasonably be compared. So there's some alignment with electoral adequacy there. There's also some very interesting work coming out of the UK. There's a scholar at the University of East Anglia named Toby James who has his own measure of how we can assess election performance. And there's some, resonance with electoral adequacy. He's applied his framework to the UK and Canada. I'm obviously focused on the US, but I think there's some good complementarity between our projects. And finally, in the US, there is a group of election scientists. It's a multidisciplinary group of mathematicians and engineers and natural scientists who have had workshops and actually submitted a proposal to the National Science Foundation based on precisely what I'm talking about, like research to inform how we can better improve our elections. This is from their research proposal, or their grant proposal, and the competencies that they identify as most important and crucial, you can see sort of align with my framework based on electoral adequacy. I don't know that there are lawyers involved with this project. Again, it's social scientists, mathematicians, but we need more lawyers. You'll see that the third issue that they cite is federal and state election law. Let's bring legal expertise into this as well. But this list on its own is interesting, just as it reveals how complicated elections are. And all of the expertise that you need on board in order to pull one off effectively. And to go back to the framework, most jurisdictions, they don't have the resources or the capacity to do this. But this is what we're striving for. So I know this was a little bit wonky, but again, in this particular moment, Congress is not going to save us. The Supreme Court is not going to save us. We can't hope for state legislators on their own to necessarily just become advocates of good governance. And scholars are left in a position where we have to wrestle with how can we actually be beneficial in this context. And I'm part of a small group of people who think this is sort of the pathway forward. It's the best investment of our time as we are confronting, pretty difficult headwinds. So I'll stop there, and I'm happy, I should say, to talk about this or any of the more sexy topics in American politics or elections that you might be interested, whether the Supreme Court or midterm predictions or whatever. But thank you. This slide was my clever attempt to suggest that it's an uphill climb that we're facing, yeah.
Thanks. Very informative. And maybe think the democratic structures, I think particularly about the last election and how poll workers, election workers were threatened from the administration itself, where people were getting death threats. Is there anything in process on a federal level to help secure, the security of election workers?
Unfortunately, there's a marked increase in threats to election workers, death threats. Many people have, these were just citizens who would volunteer, and they've chosen not to participate anymore because they've received death threats. It's a violation of federal law. So there are laws in place that make intimidation of voters and or poll workers a federal crime. But as I always say, that requires enforcement, which means the Department of Justice has to invest time and resources in enforcing that law. And one of the, we have a highly decentralized system in the United States with roughly, 8,500 different electoral jurisdictions. There are pros and cons to that. One of the cons is that oftentimes the law enforcement officials who are tasked with following the law and protecting people are more and more on board, right, with the intimidation. I mean, there's this movement for constitutional sheriffs in the United States who are, very much election deniers themselves. So the short answer is yes, it's a violation of federal law, but we need federal government investment in order to enforce that law, where in states where you can't trust the state officials to do so.
Thank you. Thanks so much, Josh. That was super interesting. One of the things that often comes up when people study, when people discuss how access to elections can be improved is the question of whether voting day should be a holiday. Mm-hmm. That was not something that you discussed, and I'm just curious if that goes beyond adequacy. Is that a nice to have, but not strictly necessary?
I think it's, well, I'll put it in the category of very important. Many people, of course, have difficulty voting on one single day. People will debate whether or not everyone should have, a week, 2 weeks, 3 weeks to vote early. This is obviously tied up with the debates about whether people should be voting by mail. I would like to see Congress change the day. It's not set in stone, right? It could be changed. But I think that states in general should provide more time for people to vote, but that's going to be circumstance dependent. And I emphasize that because one of the criticisms that H.R. 1 received was that it mandated 2 weeks of early voting everywhere. And again, we're a large, diverse country. There are some small jurisdictions that have 100 people in them. And these jurisdictions said, we can't afford to go back to the resources, but we can't afford to have 2 weeks of early voting. First of all, it's unnecessary here, and we don't have the money to pay for that. So I think there was some discussion in Congress about amending that portion of it. So this is all to say that I do think we should see at the state level at least, you know how I feel about Congress. I don't think we're going to get much action from them. But at the state level, I'd like to see some amount of early days where necessary. I'll put it like that.
Yeah, thank you very much. My name is Christian Kalis from Free University. If I understood you correctly, there is no written right to vote in the American Constitution. Is that right?
Well, the state of Michigan criminalized hiring a private driver to take you to the polls. This is not generally true. This is just a law that the state of Michigan recently passed, and as I said, was recently upheld actually by a federal court.
So, but this right to vote is, you developed this by interpretation. This is not an express right. The right to vote. Is it? Right or right? Right. So, no, I'm sorry, not right. The right
oh, okay,
to vote.
I misunderstood, yeah.
Is it an express right in the Constitution or not? This is what I understood you that this is, you developed this by interpretation.
Yes.
And kind of an analogy to this, right? This education, right? This equal treatment in
Yes,
education.
yeah.
I found this very interesting. Leads to my question: is this a right against the state, or is it a right of the state, to protect fair election, to protect democracy? This would be my question. Or is it a right to equal treatment of all citizens so that they have equal access to election?
So there's
and by this to democracy.
Yeah, people are often surprised to learn this. There is no right to vote in the U.S. Constitution. We're not guaranteed that, right? This was part of the framers' compromise would give enormous discretion to states to define voting qualifications. But in state constitutions, all state constitutions have their own provisions that allow, they're worded differently, but allow for generally free and fair elections, or they protect voters in some way. There's a lot of democracy protective language in state constitutions for which there's no analog in the federal constitution. And so that's partly why I think the education analogy makes sense and why litigants should pursue these claims in state court, because I don't think we're going to get anywhere in federal court, not only because there's no express right, but also because the doctrine is just it's so state-friendly. It gives states enormous discretion. As I said, all they have to do is wave the flag of election integrity and trying to prevent voter fraud, and judges, are upholding all sorts of state laws that seem outlandish. Yes, Suzanne?
Great stuff, Josh. So fascinating. So my question is about the demonstration effect or not of what happened in Georgia and Pennsylvania. Did that have that kind of effect on particularly poll workers and election officials that said, this is the right thing to do? You need to protect, your professional, standing? Or what do you think about the lesson that might be learned from some of those examples that perhaps could go into the red state world? And because I've known quite a few poll workers and election officials, and by and large, they're very idealistic people who think they're doing the right thing. So did it stiffen their resolve in some way, or what's your read on that?
What do you mean by the demonstration effect?
That is to say, you need to stick to the count. You need to defend, your knowledge of what happened here against pressure from outside.
I mean, this was one of the highlights, I guess you could say, right, of the last presidential election, is that there was some of this resistance. Brad Raffensperger, for instance, in Georgia, standing up. This is why Steve Bannon and others have called for this sort of rash of people to run for these positions. They sort of learned their lesson and said, we don't want to have to, we want true believers in the position the next time around. So I certainly hope that even if some of these folks get in office, whatever they can do is mitigated by the presence of other people. And most state laws have some statutory assurance of bipartisan observers, or both parties can have people present, both for the voting itself, but also for the after-election canvassing. And actually, some of the most interesting research I've read recently says it's actually, there's no notable difference between having partisan elected officials versus nonpartisan. You would think that it would be better to have nonpartisan election administration. Let's just have technocrats in these positions. But the studies we have so far show that it's actually better to have a competitive environment where both parties are sort of invested. Some of this work, I should say, has been shown in international contexts as well. It's good to have sort of both parties in the room, because then that fights against the narrative that can develop if they're not in the room, right? When they observe something from the outside and then run with it, and it winds up, as some sort of Twitter thread or whatever. So just based on that, I think I'm not opposed to having, partisans in the room, but there has to be a fine balance struck. And the concern is, of course, with like operating a Secretary of State office, is that you have so much authority on your own in that position that unless you have balanced government elsewhere in the state, we're going to have a constitutional crisis of some kind. So.
Hi, thanks for your talk. My name is Johannes Timm. I work at a think tank here in Berlin. I would like to ask you about your assessment of the independent state legislature doctrine. I guess we know that there are some justices on the Supreme Court who have expressed some sympathy for this concept.
Yeah.
And I guess the thing that's in the case right now is whether state legislatures can make up the rules without review by the state Supreme Courts or the governor or the other institutions in the state.
Yeah.
But one extreme version postulates that the state legislatures can decide the elections for themselves by completely ignoring the vote. Is there a chance that that can go anywhere in any state, or is that a real thing, or is that a red herring?
So I have the challenge now of trying to simply explain the independent state legislature theory, which is very hard. I'll do my best. So this is another case that the Supreme Court is hearing this term. Many of us think it's the most worrisome case, actually, that the court is hearing this term, but it's very intricate, so it's hard to explain simply. But our Constitution, the federal Constitution, empowers state legislatures to control the times, places, and manner of federal elections. And because the text expressly refers to state legislatures, what these state legislatures are arguing is that we have plenary authority to regulate elections. In other words, we pass a law, our state Supreme Court invalidates that. That's null and void because the U.S. Constitution expressly only refers to state legislatures. So it's a radical notion that would empower state legislatures. It would basically absolve them of any kind of review by other bodies in the state. This is sort of related to the claims that Trump lawyers made in the wake of election 2020 in Pennsylvania and elsewhere. So I'm actually involved with an amicus brief right now that we're sending to the court on this. But so I'm worried about the case in general, and I'm worried about what the justices might do with this and how they might empower state legislatures. I have to say I'm not as worried about the presidential electors issue. So the second part of this gentleman's question was about whether, if we empower state legislatures, they then would have plenary autonomy to select which slate of electors gets sent to Congress in presidential elections. And I'm not worried about that because even in that context, state legislatures are not the ones that certify elections. And they can't change the rules of an election after the election has taken place. So if we game this out, what we're worried about is, let's say in Arizona, let's say Biden runs again, he wins Arizona again. The legislature then says, we don't think Biden should be president. We're going to send a slate of electors with Trump or Ron DeSantis or whoever, regardless of what the vote outcome was. They can't do that. That would violate the Equal Protection Clause. It would violate prohibitions on treating voters arbitrarily or disregarding their votes. So I'm not worried about that presidential scenario. I am worried generally about them empowering state legislatures. Yeah. No one in the room understood any of that. That was just you and I having a conversation.
Okay. Thank you for a wonderful talk. And I have here an undergrad student who is working for a nonprofit organization that is trying to get students registered and plan to vote. And he is asking, well, first of all, he tells us that they are having great success in connecting with 10,000s of first-time voters. But is there anything they can do besides advocacy and getting other groups involved? What, in short, can be done on a grassroots level?
Yeah, so first of all, congratulations. I mean, that's great. I love to hear that sort of thing. There is an important distinction between registration and mobilization. So I would answer by saying it's great to get people registered, particularly first-time voters. I wish we had a lower voting age in the United States. Countries that have lower voting ages, it's shown that when people are entered into the democratic process early, they tend to be recurrent voters throughout the course of their life. So there's these high school programs that are great for having young people vote when they're like 10 years old, just to habituate them to the process. You know, it's great. But I would just say to this, person, I mean, their judgment might be better than, you know, some of the adults. But you also have to mobilize people. So you get them registered in step one, but then a lot of research shows that you have to sort of activate people as the election is approaching. So that's what I would encourage as sort of a follow through to just the initial outreach.
Thank you for your lecture. With all what's happening on Supreme Court level and all the attacks on voting right in the red states, isn't it already a coup? And don't you fear sleepwalking into the loss of democracy in your wonderful country?
I fear it often, yes. I definitely am worried. Many are worried. There's a lot of, you know, there's these claims of alarmism, right? I mean, there's books, How Democracies Die and such, and I read them and they don't strike me as alarmist. I mean, we have lived through what amounts to an attempted coup, right, on January 6th. This is one of the remarkable things about this moment. We don't have to guess at what they want, right? They're telling us precisely what they want to accomplish. They're moving the pieces on the chessboard. Not in a surreptitious way, right? So we don't have to guess at what they want. And, you know, I have a hard time sort of imagining us like slouching towards fascism or something within the next 4 years. But I agree with people like, to go back to this conversation in the Times today with Tim Alberta and Jamel Bowie, I think there is a good likelihood we will see sort of, I think Jamel Bowie calls it sort of horizontal, not civil war, but divides between the states. We're increasingly seeing these sort of zero-sum situations where California, for instance, says, if you're a company that wants to do business in California, here are the climate, you know, provisions you need to adhere to. Texas immediately says, if you adhere to those, you can't do business in Texas, right? So there's going to be this continued sorting between the states, which is deeply problematic because as someone who's lived in the state of Oklahoma for a couple of years, there are many Democrats in Oklahoma. There are many Republicans in California, right? We're trained when we look at that map and we see red states and blue states to forget, right, that there are these pockets, right, of you know, red voters in blue states and blue voters in red states. So this increased sorting is not the solution, but it seems like that's the way that we're trending.
Thanks for a great presentation. I've got one sort of optimistic clarification question to a point that was made, and then one question which leans toward the pessimistic. On the optimistic side, I do, especially for German friends here, I think it is correct to say there is no right to vote in the Constitution, but there's a big but, which you alluded to when you spoke about the equal protection and claims that could be made based on equal protection. But it also goes beyond that. We have this 17th Amendment to the Constitution, which provides for the direct election of U.S. senators. We have direct election of members of the House of Representatives. So I think you could make an argument that there is a right to vote in our Constitution. That's the optimistic point. The pessimistic question is, you know, your scheme that you laid out, funding, management, and
democratic structures.
Even with that third bucket, allowing for the fact that the third bucket does talk about democratic structures, one could criticize that depiction by saying that, and I wouldn't criticize it this way, but that it's a technical solution to a cultural problem.
Yeah.
That our democratic institutions, a necessary condition for our democratic institutions is what you laid out. But the sufficient condition for our democratic institutions, or vice versa, I never quite know which is necessary and sufficient, but the other component is without a cultural appreciation of what democracy is, norms that are not reflected in technical provisions, we're going to lose this battle. And I'm wondering what remedies lie in that realm.
Yeah, it's a profound question and obviously a very difficult one, and one that we spoke about last night at dinner, and this is what keeps me up at night, is the thought that, I'm sort of fighting a battle at the wrong location or something, right? Because the place to fight this battle is in inculcating civic values, right, and educating people. And that starts, it's cliche to say, but it's like that stuff starts in the home, it starts in public schools, it starts in communities. I don't know how we work out of the situation we're in, right? Again, 50% plus Republican candidates election deniers. How do we work out of that? This seems like a problem for political psychology, not a problem for a lawyer. So that's what I worry about, is that the battle is lost in this way because so many people have such strong ideological views about what is right. And as you and I discussed, when you present evidence to someone in a rational way, we know, right, that leads them to dig their heels in. They're actually less likely to adopt the true belief once you present them with the facts. I'm sure we'll keep this conversation up for the next couple of weeks while you're here, but it's an issue of media, it's an issue of education. The biggest divide, I was having this conversation at dinner, the biggest divide in the country between Democratic voters and Republican voters right now is based on college degree. Make of that what you will, but that education gap now outperforms every other distinction that surveys have captured. So that suggests there is a cultural problem, and it's one rooted in access to education and knowledge formation and such. So it's an interesting way to think about how we could incorporate that into a framework like this. I don't disagree at all that it's essential.
Well, this is kind of a follow-up question to the previous gentleman, and also to what Kallis asked you, namely the question of the right to vote. What strikes me is that the right to vote is not a precondition of political struggle, but is the object of political struggle. And the question is, doesn't that require a reconceptualization of the idea of democracy? If the basis of democracy itself is the object of the struggle, then the question is whether we are in a pre-constitutional situation in which either the idea of the pouvoir constituant of the people is required, or we have even a civil war. These are the two alternatives. So I think a conceptual clarification of the status, the conceptual status of the right to vote is required.
Also a very good point. So it strikes me, it seems like the right to vote exists in a almost liminal status in some ways. There is, to Eric's previous point, there is certainly a strong argument, one I agree with, to be made that we have something resembling a codified right to vote based on the amendments that have been enacted, particularly the 14th Amendment, So yes, it's not expressly mentioned in the text, but that doesn't mean that we don't have even a cultural understanding of that assurance. It's hard to imagine that being stripped entirely. So I don't know if I agree we're necessarily in a pre-constitutional moment where there's nothing guaranteed. There are things guaranteed, but to go back to an earlier point I made, what precisely is guaranteed is just the subject of endless contestation, right? What are the actual parameters of what it is we have? So that's why it strikes me as being in more a sort of liminal status rather than the either-or scenario that you propose. But I think this is also a unique problem in the United States because of our decentralized system, right? It's not like, because of the framers' bargain, we give states the authority to determine voter qualifications. And if you are eligible to vote in a state election, you are necessarily eligible to vote in the federal election in that state as well. That's what our Constitution says. So from the founding era, we've tethered the right to vote in federal elections to the right to vote in state elections and given the authority to set the qualifications in the states. That's why I think the foundation is so weak, and that's why I'm trying to develop ways to shore that up and create a more robust foundation, that will persist, that will provide some stability across states.
Ivo happened to be a business lawyer, asking, especially constitutional-wise, that alludes to the prior questions in a certain degree. Are they lacking the knowledge of state law legislation and the state constitutions all over the United States, of course? Are there some clauses within those state constitutions? Because I sense the major battle has to be fought before state constitutional courts if to achieve anything because of the delegation aspect of the federal constitution. Are there some constitutions on the state level that allow for further, let's put it that way, restrictions? Are they that open in terms of clauses that are contained in those state legislations that would allow for some states, regardless whether blue or red ones, to further impact this right of vote or restrict it, limit it, voters registration, electoral district redrafting, etc., pp? Or are they mostly likely, in comparison, mostly similar to one another, not allowing for fundamental limitations? Thanks a lot.
What's happened is there is model legislation that gets proposed and enacted in one state, and then you see the same legislation show up in other states. This is true. It's true in some blue states, but it's mostly a red state phenomenon. And people have tracked this. They can do, there's these programs, right, which allow for tracking of legislative language, and you see the exact same language showing up in state to state. So it's model legislation. And there's really, so to answer your more fundamental question, the federal Constitution sets a floor, right, on the right to vote. So you can't go beneath that floor. A state could not just say, we're going to not allow black people to vote, or we're not going to allow redheads to vote or something. That would clearly violate the federal Constitution. But what they do above that, they could certainly go beyond, and in some ways that's what I'm arguing is for them to go beyond, but that floor is far too low. Right, that's sort of the point I'm making, is that floor should be much higher in the first instance, because what states can get away with in regulating elections is vast. And once one state succeeds in enacting one of these problematic laws, you see other states follow because they feel like they have the green light, right? It's been tested, survived a court challenge. Other states jump at the chance. Yeah, that's one possible path I think we should pursue, yeah.
Okay, hi, Alan Benson, my name. There was a recent Time magazine article about a group of electoral officials, bipartisan and so on, called the Defenders. Have you read that article or so? Have other people read it?
I haven't read that one. I think
I'm
familiar with them.
Are the Defenders, is that a concept you know about, or are they known in the States a lot? And electoral essentials, would they be moved by your idea about the essentials? I can't speak to it because I'm not familiar with who they are exactly. I feel like I've heard the
the name before, but there are groups, for instance, the Bipartisan Policy Commission. Many of their recommendations align very much with what I'm suggesting. So there are groups. I'm not familiar with the defenders in particular. It sounds like maybe they're doing similar stuff. Okay.
Josh, thank you so much for that. That was amazing clarity. As you're speaking and pointing us towards ideas around coming up with electoral adequacy, I'm just wondering, where does the electoral college the work relative to this? You know, why? Because I'm thinking of the insurrection and Mitch McConnell's statement at that, where he said, not to worry, as long as the Electoral College stays in place, we're okay. So what's that all about relative to my ability to vote as an American citizen?
I appreciate the question because it allows me to end on a positive note, which I rarely get to do. So it doesn't have any direct impact on your right to vote. It has a lot to do, of course, everything to do with certifying the slates of electors that get sent to Congress for approval. That's, of course, what the insurrectionists were trying to disrupt. And the problem is the law that governs the Electoral College process is incredibly antiquated, and experts can't even understand it. I think it's from 1887. A lot of my colleagues across the academy have been investing time in trying to figure out, what does this Electoral Count Act say? That's the federal law that governs this process. Everyone acknowledges it's a mess, including Mitch McConnell. And so I can end on a positive note because I can say there is bipartisan support for reform of the Electoral Count Act that can survive a filibuster, and Congress has said it will enact that after the midterms. And so on that precise issue, in terms of tightening up the process to prevent another disruption of the Electoral College like we saw on January 6th, it seems like the Congress will do that limited thing after the midterms. In terms of reforming the Electoral College, that would require a constitutional amendment, which is implausible, and there is no appetite whatsoever for Republicans to change to a system where the winner of the popular vote is the president. I mean, they have zero incentive to make that change. So the best we can hope for is this Electoral Count Act gets reformed, which will, of course, raise new questions, but at least will tighten up a lot of the opportunities for gamesmanship that we saw in 2020.
I think although you thought that you were ending on this note, you're not ending on this note. There is a final question, but you still have to transfer and positively.
Yeah, thank you very much. That's very kind. In Germany, we have this right to vote, and it was developed by our constitutional court even into a right to democracy. But we face now another challenge. Many people don't use their right to vote and don't participate in elections. So my question would be, what do you think about an obligation to vote?
Yeah, I mean, they have an obligation in Australia, as I understand it. I think you're fined $5 or $10 if you don't vote or something. It would never fly in the United States. It's just, it's a violation of our conception of individuals to do what we want, you know, but I am going to end on a positive note. And it's, people often ask, you know, do I have any reasons to look at recent elections and be, I don't know about optimistic might be an overstatement, but somewhat positive. And this might surprise people. I think that the turnout in election 2020 is a positive thing. I obviously disagree vehemently with the way that many people voted. But that was that was record turnout. And I think that's a good thing. I want more people participating in the process. So if you'll let me, I'll end with that positive statement. But thank you.